Since I started at the university, I read her papers when I prepared my thesis. Thank you very much. She is Vice President Emeritus of the Spanish Constitutional Court, a partner at Cremades and Calvo Sotelo, abogados. Thank you very much.
Thank you, Eva. Ladies and gentlemen, dear students, I was asked to speak in English, so I am very obedient, so I will speak English. I am extremely pleased and honored to be at the campus of Universidad Carlos III in Madrid, joining with remarkable and outstanding speakers from several countries and backgrounds. I particularly would like to thank the International Council of Environmental Law and the Global Judicial Institute for the Environment for organizing these dialogues on nature, justice, and peace. I attend this event not only, as Eva said, as Emeritus Vice President of the Spanish Constitutional Court and partner at Cremades and Calvo Sotelo law firm, but in representation of the World Jurist Association, partner of this event. A world ruled by law, not by force. This is very important. And it has been the World Jurist Association's mission since its founding in 1963. The World Jurist Association was created as an answer to an international outcry for a free and open forum where judges, lawyers, law professors, and other professionals and students also from around the world could work cooperatively to strengthen and expand the rule of law and its institutions throughout the world. As a non-governmental organization with special consultative status at the United Nations Economic and Social Council, the World Jurist Association provides a unique forum for the international community. With more than 60 years of accomplishments, the World Jurist Association is one of the few organizations of the world working with such a broad range of stakeholders to promote the rule of law as the path towards world peace. Our members include sitting and retired chief justices, judges, government officials, law professors, lawyers, law students, and law-related professionals. We have national presidents in countries around the globe, and our board of governors represents every continent and every aspect of the legal profession. We have worked closely with governments, non-governmental organizations, and international associations to foster a cooperative dialogue on world peace. Through our support, decision makers from around the world work together as individuals rather than representatives of a particular country, class, or ideology. This is a very brief look at the ways in which the World Jurist Association has sought to build the foundation for a system of laws that will ensure peace without using the force. The World Jurist Association is committed to its continuation of ensuring peace throughout the rule of law for all generations. Climate change issues have been, since its foundation, a great concern for the World Jurist Association. Recent developments in the energy market and the illegal invasion of Ukraine has doubled those concerns. That is why one of the main topics in 2023 World Law Congress organized by the World Jurist Association that will be held in the city of New York on July 2021 will focus on energy transition and climate change. There will be a significant representation of the International Council of Environmental Law and the Global Judicial Institute for the Environment. I am sure we will learn a lot during this discussion, and I also hope to continue the conversation we are starting now during the World Law Congress at the New York City Bar Association and United Nations, the venue of this legal Davos that this year celebrates its 16th anniversary since its first summit in Athens in 1963. Thank you again for your kind invitation, and to all organizers that have made possible this gathering in Madrid. I wish you a very fruitful discussion, and we are waiting for your conclusions, and the world is waiting also for your conclusions. Many thanks.
Thank you very much. Now, Diego Solana, he comes from a very important lawyer bureau which collaborates with our university from a long time. For example, in our Master de la Abogacía, Master for Getting a Lawyer. Diego Solana is the International Advisor of the World Law Foundation Partner and Cremades Calvo Sotelo Abogados. Thank you very much.
Thank you very much, Eva, for your kind presentation. I wanted to start also with some thanks to Antonio Benjamin, to Monse, of course, to Victor, to Teresa, because thanks to all of you, I think we are doing something with an impact, and this is the beginning of a collaboration that I hope that ends up in New York on July 21st at the United Nations and at the New York City Bar Association, where we will be able to continue this conversation. Just share with you some thoughts, because I have to say that I was not really a truly believer on climate change, energy transition. I was more, I studied the Chicago school approach about companies and how really everything was for the shareholders, and that's really was the only and sole purpose of a company. I was talking with someone before, a teacher, no? That's really the purpose of a corporation was to make money, to make profits for the shareholders. No? But for some years ago, I started to change a little bit my view. I started to read a little bit more about ESG, about the importance of stakeholders, and not only about shareholders. And really, and I recommend all of you, maybe you know what the work of Michael Porter talking about ESG and stakeholders. It was a turning point for my approach to energy transition and to the law and to the idea of stakeholders. No? And he basically says, so that's my briefly summary of all his work, is that being concerned about climate change or energy transition is not really a moral position. You are not a better person because you are concerned about energy transition. Actually, you are focusing on creating more wealth. So it's really a way to create more wealth, and that more people can enjoy that part of the wealth, of that wealth. So really, this guy really make it, sorry, my excuses. Sorry. And really changed the way I read it like 7 years ago or so. And now we're on an organization that, like very, very well my colleague Encarnación Roca said, we're in a global campaign of promoting rule of law. And I am now a believer. So, and from studying and from listening to people like Encarnación, like Monse and Teresa and a lot, Antonio and other people, I truly believe that the rule of, without the rule of law, energy transition is at risk. So I really believe that there's a lot of ways we can collaborate. No, the rule of law. Is not only, is a way and an approach to the world, not only based on strictly the law, but with a purpose, no? And if we understand that the rule of law has a purpose, and that can make the world a better place, a more wealthy place, not only a moral position, I think that I hope that we collaborate a lot, and I hope to see you all in New York on July 21st. And as Encarnación was said, I'm really looking forward for your conclusion and to learn more about this, this area. So thank you very much, everybody.
Thank you very much, Diego. I am very happy to introduce also Patricia Cameri from UNEP, an important partner of this event. She is the director of Law Division. She is online. Welcome, Patricia.
Thank you very much. Professor Eva Maria, I'm very happy to be here. Justice Antonio Benjamin, the Vice President Emeritus of the Spanish Constitutional Court, Professor Castellos, and other distinguished colleagues, ladies and gentlemen. It is really a great pleasure for me to speak at this event, where I'd like to give a broad and global perspective on nature, justice, and peace. Distinguished participants, today our planet is dealing with the three interconnected crises: climate change, biodiversity loss, and pollution. Time is running out, as we keep being told. People around the world are in the fight for our lives, and sadly, if we do not heed the call of science, it appears that we may lose. We have used the equivalent of 1.6 Earths to maintain our current way of life, and ecosystems cannot keep up with our demands. There is extreme loss of life, with millions of plants and animals threatened with extinction. Global temperatures keep rising. The air we breathe, water we drink, lands we live on, soils we feed off are increasingly being polluted. Our planet is fast approaching tipping points that will make the negative impact on nature irreversible. These problems are transboundary and global, not national. We know that the increase of greenhouse gas emissions has led to drastic climate change and related events. We need transboundary answers, international cooperation, and a whole of society approach. Environmental justice and the environmental rule of law are of central importance in addressing some of the challenges we are facing. Let us not forget the important advancement made when last year the United Nations General Assembly recognized the human right to a clean, healthy, and sustainable environment. Underpinning this right is the imperative that we live in harmony with nature and respect the planet's limits. Now it is time to implement this human right at all levels. Courts specifically will have to integrate human rights approaches in their decisions on the environment. This year, as we prepare to publish UNEP's Global Climate Litigation Report, we have noted an increase in the number of climate cases. We have also noted some interesting regional trends in the report. International and regional courts are also working on environmental justice, some for the first time. Advisory opinions are currently being prepared in the International Court of Justice, the International Tribunal for the Law of the Sea, and the Inter-American Court of Human Rights. Moreover, cases have been brought before regional courts such as the European Court of Human Rights. To sum it up, climate litigation is on the rise. Countries will need to accelerate implementation of the environmental rule of law to address environmental injustices and promote rights. Environmental rule of law highlights environmental sustainability by connecting it with fundamental rights and freedoms. UNEP's Law Division is deeply committed to advancing the work of environmental rule of law, and environmental justice is imperative in this regard. That is why our partnership with the Global Judicial Institute on the Environment to build judicial capacity around the world is so important to us. At the core of our flagship Montevideo program to support the progressive development and implementation of environmental rule of law is environmental rule of law imperatives as well as environmental justice, which will contribute to peace. I wish you very fruitful deliberations and look forward to the continuing discussions in New York. I thank you.
We are not hearing you.
Okay,
I finished.
I try again. Now it's difficult to introduce Professor Abad at this university. She's one of our most important research at the law department, and of course, she's the person who has prepared this event. Professor Abad Castelos, Professor of Public International Law at the Carlos III University, Vice-Chancellor of this institution, and co-director of its International Secretariat. Thanks to prepare this type of event at our university, opening our university to the world. Thank you very much. Thank you. It is a privilege for
Microphone.
It is a privilege for me to intervene in this session. Welcome, everyone. Good afternoon to our in-person speakers and attendees, and good afternoon, morning and night to our online speakers and audience. The topic of today's meeting lies in a zone of intersection between nature, justice, and peace. The starting point is that nature is much broader than the environment. It is even qualitatively different. We, human beings, are part of nature. In the era of the Anthropocene, with a triple planetary crisis of climate, biodiversity, and pollution, a new paradigm is needed, with a holistic approach which also systematically integrates human rights. At the same time, it must be considered that there can be no peace without justice, and there can be no justice without peace. They are two interdependent concepts that are more related between each other than current society thinks. Precisely for this reason, a change of mentality concerning nature is needed to face some of the most urgent challenges for the future of humankind and the planet. It is necessary to improve the natural resource governance, to make the decision-making processes more inclusive, to foster transparency and accountability, to uphold the rights of indigenous peoples, to guarantee a sustainable use of land and water, to deepen the process of greening human rights and ensure intergenerational equity, amongst many other needed steps. Both governance and management of nature and natural resources are key to take care of the systemic balances of the earth and therefore of mankind. Legal practitioners and other actors are decisive. Scientists and academics doing research. Legislators, decision makers, and diplomats initiating or negotiating strategic processes. Judges interpreting, implementing, and enforcing obligations in courts. Companies conducting adequate due diligence. Civil society advocating alternative and emerging viewpoints at national and international fora. Everyone has a vital role to play. Today, we have the honor to host leading professionals as speakers and also well-recognized experts among the audience. Hence, we can expect inspiring dialogues and reflections that expand our horizons. We deeply appreciate the support from the organizers, the Universidad Carlos III de Madrid, ICEL, and the Global Judicial Institute for the Environment, and from the partners, the World Jurists Association, UNEP, and the World Commission of Environmental Law. This is teamwork. Many thanks indeed to all of them, as well as to the speakers and to the audience. Thanks.
Now the welcoming table has ended. I would like to give thanks to all, especially to Justice Antonio Benjamin, who has came from Brazil to stay here with us. Thank you very much. Now is over and continued with dialogue on justice and nature. Thank you very much.
After the opening, we begin with the first
panel, a dialogue on justice and nature. As I explained, this is, in a nutshell, a much larger panel that we are going to have in New York. Here we have 5 speakers. In New York, we are going to have 12 justices from around the world. My co-chair is my dear friend and colleague, Christina Pack. I wonder if she's connected. Christina is from the Asian Development Bank, and she is the head of the Judicial Education Program for Asia and the Pacific. But I'd like to know whether she's connected.
I'm here, Justice Benjamin. I'm connected. Hi, everyone. I'm here. Can you hear
Okay, let me check if the other colleagues are connected. Justice Luc Lavrissen, Chief Justice of the Constitutional Court of Belgium and Chair of the European Union Forum of Judges for the Environment. I think I heard your voice, Luc.
Yes, I'm
Good.
here.
The other speaker is Justice Ricardo Lorenzetti, former Chief Justice of the Supreme Court of Argentina and still a distinguished member of that court and professor of the University of Buenos Aires Law School. Ricardo.
Yes, Antonio, I'm here. Can you hear me?
Gracias. Sí, yeah, very well. Then Justice Samson Okongo, Emeritus Presiding Judge of the Environment and Land Court of Kenya, and a judge, I believe he's now on the shore of Lake Victoria. Samson, are you with us?
I am, Justice Antonio.
Delighted to hear you. And finally, Justice Filomena Singh from the Supreme Court of the Philippines. I wonder if Filomena is with us.
I am here. Good evening to everyone. Good evening,
It's
Justice
really
Benjamin.
late evening for you and for Christina Pack. So in this panel, right next to me, we have Justice Eduardo Ferreira McGregor, Vice President of the International Court of Human Rights, and a very distinguished scholar in not just human rights, but environmental law, and I would say everything in law. Public, private, and someone that is well known in our community. Each one of us will have 3 minutes. I won't say much about it because my purpose here is to chair, but just to perhaps introduce the discussion or to provoke discussion. When we mention the environmental rule of law, in my view, we have at least 4 aspects, not just the traditional one. Still, several of our colleagues, both in academia and in judicial systems, see the rule of law as the rule of laws. And this is wrong, as we know. We can have bad laws. So it's rule of law involving laws, but also rule of good laws, especially in the environment. Within this purpose of protecting the environment, the good laws need to be enforced. So enforcement is crucial for the environmental rule of law. And the 4th pillar that I would list is accountability. It's not necessary to have laws. It's not just laws or just good laws or good laws that are implemented. It's relevant to have accountability. So we judges and the legal community need to explain, to show, to inform society about what we are doing in terms of implementing the good laws that we have. Sometimes the good laws are not there. Christina Pack, you now.
Thank you, Justice Benjamin. Honorable justices from around the world, distinguished speakers, our development partners, ladies and gentlemen. Warm hello from the Philippines. It's a great privilege to be part of this distinguished panel, and big thanks to Professor Eva Maria Agudo and the Universidad Carlos III de Madrid for organizing this important event. My introductory remarks will focus on judges as key stakeholders in responding to the triple planetary crises of climate, nature, and pollution, and their essential role in upholding and interpreting and validating laws, as well as protecting the rights of citizens and other beings affected by these global crises. In adjudicating hyper-complex environmental, biodiversity, and climate cases, judges need to consider policies and their rationale. They need to understand science that is quite technical and evolving quickly. And judges must grapple with the rights of emerging stakeholders, including rights of nature, Earth's non-human species and future generations, and more recently, it was mentioned before, shareholders' rights and other business interests in the corporate sphere. Additionally, judges are called to adapt the law to respond to unprecedented challenges with increasing number of novel legal claims involving international stakeholders. In deciding, judges must balance economic, environmental, social, and cultural considerations and devise appropriate and innovative remedies and damages. So making these complex and difficult decisions require knowledge, resources, and networks. Perhaps I'll share quickly just the experience of the Asian Development Bank in supporting judicial education since 2010. We have been investing in judiciaries because they are responsible for critical decisions that have tremendous sustainable development implications. In the beginning, we focused on engaging with chief justices and senior judiciaries because of their direct and indirect influence on the legal system and environmental enforcement. And with their support, courts have established green benches or green courts, judicial certification programs on environment and climate and environment, and promulgated environmental rules of procedures. Another important outcome has been the first of its kind Asian Judges Network on the Environment. Judges have expressed an ongoing need for judicial networks to help navigate the 21st century challenges. Furthermore, we have been supporting national judicial programs in several countries in partnership with judicial learning academies to ensure that the work is sustainably embedded in judicial national curricula. And more recently, we have started embedding scientific knowledge in our program to help bridge the gap between science and the law and linking judges with experts so they know where to source credible information. Judges have also expressed need for resources, particularly on remedies. And we are working on a judicial remedial orders handbook to assist in this regard. In particular, there's a greater need for preventative and restorative remedies in environment and climate cases. But perhaps the most satisfying outcome is the enhancement of environmental jurisprudence. And we have justices here who have penned landmark decisions which are cited around the world. And it is only with the sustained support of judiciaries which have made these achievements possible. In conclusion, judicial education must continue in times of our triple planetary crisis, not just with select number of judges, but it must be provided at all levels, as well as in specialized courts. For example, in commercial courts, where environment and climate change matters are coming before them in a variety of contexts. ADB sees judicial education as an opportunity for development partners to invest in the very arm of the government empowered to spot impediments to effective government and private sector action on the environment and climate change. It has been a remarkable journey, joining forces with our longstanding partners, such as the Global Judicial Institute on the Environment, United Nations Environment Program, the ICEL World Commission on Environmental Law, and International Council of Environmental Law to support judiciaries during these challenging times. Without judicial education and environmental law, inclusive and sustainable development is at stake. Thank you. I will now hand the floor back to Justice Benjamin.
Thank you, Christina. I forgot to mention, but I do it now, that the Asian Development Bank has the finest judicial education program on environmental law in the world. And we are talking about a region of the world that is not just geographically gigantic, but in terms of population as well. It goes from Australia, New Zealand, China, Indonesia, the Philippines, the Pacific Islands, Mongolia, and then India, Pakistan, Central Asia, the Caucasus, and am I missing anything? I mean, it's it's such a
You covered it all, Justice Benjamin.
yes. The Caucasus is the new addition, so to speak, to this enormous portfolio. So, Christina, many thanks. I also like to mention, because I forgot to do so at the opening, that the partners of this event are the World Jurist Association, and our colleagues, Diego was here, and my colleague from the Constitutional Court as well, UNEP, the United Nations Environmental Program, and the World Commission on Environmental Law of IUCN. We are going to hear later from Professor Christina Voigt, professor of the University of Oslo Law School. The next speaker is Professor and Justice Riccardo Lorenzetti. Riccardo.
Hello. Can you hear me?
Yes, very well.
Okay.
Sí, muy bien.
Okay, thank you very much. Thank you very much. It's a great pleasure for me to share this moment with you and Antonio and all the people there. And it's also a great pleasure to participate in an event organized by Carlos III University. I've done a long time in that university, and we have a long, strong partnership with the University of Buenos Aires. Well, in a few minutes, I would like to stress 2 points. First one is, well, during a long time, we were speaking about the environmental paradigm. This is a notion larger than the idea of a new and specific rule of law, or the idea of a new and specific branch of law. We are talking about a big change all over the world, and it's a change of paradigm. With this approach, when we talk about nature from the legal point of view, we are stressing the idea that we must adopt a systemic approach based on the concept of the environment as a collective good, the merging of this environmental paradigm. For example, in the Argentine Supreme Court, we established that the environment is a collective good. I belong to the community of common use and indivisible. This the first decision was Mendoza case, but then we had a lot. It is systemic because that not only take into account private interest or the state interest. We take into account the environment interest. It's not restricted also to territorial jurisdictions, since environmental conflicts are not limited from political or jurisdictional divisions. I think this is very important from a lot of point of view, because, for example, when we look at the comparative law nowadays, we can see 4 ideas. The first one is that environmental law is only a question of a limited point of view. The most important issue is the protection of nature as a public policy matter, and the courts have no role to play in this field. This is the traditional point of view. The second is people have an individual right to a healthy environment. There are a great number of countries all over the world because this is the most traditional nowadays. protects the nature, but indirectly. It's not directly protecting the nature. The third approach is a big change. Its nature or its components are legal subjects, and they may bring an action by representative entities. The idea that nature is a subject is nowadays we have some examples. For example, India court, Supreme Court decided that the Rio Ganges is a subject. The Colombia Supreme Court decided that animals are subjects. Okay, but this is now it's a big change in the legal system. In Argentina, we decided, I think in Brazil the same, that nature is not a subject. Nature is a system, and we have to protect nature as a public good. This is the systemic approach. For example, in our civil and commercial code in Argentina, we decided that we regulate not only conflicts between individuals, but also conflicts between individual and collective goods. And the collective goods have these figures. They are indivisible, they belong to the community, and the protection must focus on the collective goods, not only indirectly, but on the first approach. This is our subject. The second question I'd like to say just briefly is implementation, because as Antonio said, very often environmental law is directed at awareness, but not at behavior. These types of regulation expose the conflict, but not resolve it. This opened the doors to the role of the judiciary. We need to understand that, first of all, our work as courts is not finished when the court has done a judgment. The courts must test the effects that the decision produces. The courts also can order the implementation to the administration, like the order to clean a river, for example, or exhort the Congress to fulfill a gap in the legal system to protect the environment. This is another field in the enforcement, because we need to talk about complex remedies.
Ricardo.
Sorry, but I am speaking about a lot of questions, but I'd like to finish here.
Oh, thank you.
I think we have a lot of work to do. But Antonio, I think you have a tight time. This is my
I could stay forever with you. However, we do have a tight program. Ricardo, many thanks. You raised several points that are relevant.
Okay, thank you.
Yeah, thank you so much. You raised relevant points that are critical to understanding the environmental rule of law. And one point is precisely a new conception of legal values and una nueva teoría de los bienes. Because as we know, we had in the past things that were not legal things. Nowadays, we have legal things that are in transition into becoming something different from the traditional legal thought of things. But we don't have the time to elaborate on those very, very relevant aspects of law. So, Christina Pack, back to you.
Thanks, Justice Benjamin. Now I'd like to invite Justice Eduardo Ferrer McGregor to intervene. He's the trustee of the World Law Foundation and the former president of the Inter-American Court of Human Rights. Justice Eduardo Ferrer.
Thank you very much, Christina, for your kind presentation. Good morning, Good afternoon to everyone. Buenos tardes, buenos días, por los que nos están viendo en América Latina. Firstly, I would like to greet the honorable judges who accompany us. It is a pleasure for me to interchange knowledge with distinguished judges from around the world. I would especially like to thank the invitation of Universidad Carlos III, International Council of Environment Law, and Global Judicial Institute in the Environment, and of course, the partnerships, the World Jurists Association, and other partners. In these 3 minutes, I think I have 3 minutes? Yes. Okay. In these 3 minutes, I want to highlight some contribution from the Inter-American Court of Human Rights. As you know, the Inter-American Court is seated in San Jose, Costa Rica. I saw a lot of students. We have internships, so you can come to the Inter-American Court to have some experience, no? Pasantías. Tenemos un programa de pasantías. But I will talk very brief. First, the Advisory Opinion 23, request by Colombia in 2017 regarding the environment and human rights. That was a very important advisory opinion. The court recognized for the first time the autonomy of the right to health and environment and the need to protect of nature. That was the first time that the court was very clear in 2017. In that opinion, the Inter-American Court developed extensively the obligation of prevention, the precautionary principle, the obligations of cooperation, and the procedural obligations. These 4 points should be performed by the states within due diligence, which is an obligation of means instead of results. In a recent case, 2 months ago, we ruled a very important case from Barahona Bray versus Chile. The court established standards based on the content of the Escazú Agreement, el Acuerdo de Escazú. This is a very important tratado regional, Escazú Agreement, the region's first treaty on environment matters, and the world's first to introduce provisions on human rights defenders in environment matters. In that case, the court recalled international environment standards and highlighted the importance of states adopting effective measures to protect the right of freedom of opinion and expression and the access to information. Also based on the Escazú Agreement, the court remarked the importance of ensuring citizen participation in environment matters, which is of vital importance for the realization and protection of the right to a healthy environment. In addition, I just mentioned one more case. Indigenous communities members of La Cajonat Association versus Argentina. The court remarked that the right to a healthy environment constitutes an universal goal. The court established that this is a fundamental right for the existence of humanity and recognized its autonomy even in the absence of certainty or evidence of risk. The court asserted the violation of the right to healthy environment, right to water, right to food in their interrelation, as well as in their link to indigenous cultural identity. Currently, the court is deciding on a case called Comunidad La Oroya versus Peru. This is the first case heard by the Inter-American Court that relates exclusively and extensively with environment matters. It is related to suspected damages caused to a group of inhabitants of the community of La Oroya due contamination carried out by a metallurgical complex. And lastly, we're working on an advisory opinion jointly requested by the states of Chile and Colombia. The court was asked to clarify the scope of the state obligation for responding to the climate emergency under the frame of international human rights law. I'm sure that this advisory opinion will become a landmark decision and will be an important contribution for nature, justice, and peace. Thank you very much.
Thank you so much. Gracias. As Justice Eduardo Ferrer emphasized, the environmental rule of law is not just about domestic national legislation. It is also about international law, international agreements, treaties, conventions, hard law, soft law. And this is a point that sometimes we forget. So many thanks for highlighting this aspect in the environmental rule of law. Christina Pack.
Thank you, Justice Benjamin. Next, we'd like to invite to the floor Justice Philomena Singh of the Supreme Court of the Philippines. Justice Singh.
Thank you very much, Christina and Justice Benjamin. Again, good evening from the Philippines. For my 3 minutes, what I'd like to focus on is what I've been advocating in our country and in the international conferences I've been invited to. I propose a re-examination of the traditional role that the judges or members of the judiciary have played in our efforts at the preservation and conservation of nature. And it is a move away, a policy shift from the traditional passive role of merely adjudicating cases, passing jurisprudence, interpreting laws, but to a more proactive role in terms of implementing reform initiatives that are more community inclusive, issue-centric, and grassroots friendly. I find that one of the biggest stumbling blocks to our efforts is the fact that the people at the grassroots level cannot comprehend the dense and complicated and highly technical topics that we talk about in terms of environmental justice. And unless they understand it in their own level, they will not feel the urgency that we all feel because we understand the things that need to be cascaded to them in a language, in a manner, in an approach which they will be able to comprehend easily. And so the approach that we have adopted in the country, in our country, in the Philippines, we have tried out through what we call our justice zones, where we have a sector approach. We involve law enforcement, we involve the prosecution, we involve the public defenders, and we involve the community, including law clinics and other free legal aid providers, in going down to the grassroots and addressing local issues involving the environment in particular communities. And through this sector approach, we have done capacity building and training as a sector. By doing so, we have broken down the barriers. The prosecutors and the law enforcers talk about case build-up together with judges who are able to offer them guidance on what is missing when they come to court, which results in offenders going scot-free. So these are the efforts that we have tried, and in the third quarter of this year, we are set to launch our first ever Green Justice Zone, where we are focusing on a particular community. It's a city which is known for its environmental issues. And through this Green Justice Zone, we hope to involve the community more in our efforts at planet conservation and the fight to protect nature as a whole. And this is the particular advocacy that I have been espousing, that judges should not just wait for cases to come before them and adjudicate them, but to also go out through reform initiatives and programs and be more proactive in involving the community, because we are the bridge for the community to understand the urgency of the problem, we draft or we propose or promulgate the interpretation of the laws. We are in the best position to explain it in a manner that the grassroots will be able to understand. So thank you very much for this opportunity to share with you briefly my advocacy.
And thank you for reminding us that the environmental rule of law is about judges, but not just about judges and laws. At the end of the day, all actors that work with the protection of the environment in the administration, in parliaments, and in society have responsibilities with the implementation of environmental laws. You also highlighted the fact that often is forgotten that judicial decisions are not just to adjudicate a specific conflict or case. Judicial decisions have an educational role, and this is quite relevant in the formulation of the environmental rule of law. Christina Pack.
Thank you, Justice Benjamin. So we'll now go from Southeast Asia to Europe, and it's my great honor to invite Justice Luc Leverson, the Chief Justice of the Constitutional Court of Belgium, to take the floor. Thank you.
So thank you very much for the invitation. It is often said that biodiversity law is the weakest part of environmental law. And indeed, in many instances, there is no one to trigger the enforcement of it because breaches of that law are not reported, or interested parties like NGOs lack standing in various jurisdictions. And sometimes public enforcement agencies are not willing or not allowed to act. And the problem has already been discussed at the Global Judges Symposium that was held in Johannesburg in August 2002, so more than 20 years ago. And looking to the so-called Johannesburg principles on the role of law and sustainable development, which have been adopted at that symposium, we can read that a fragile state of the global environment requires the judiciary as the guardian of the rule of law to boldly and fearlessly implement and enforce applicable international and national laws in the field of environmental law. And because nature itself has no voice, this is, I think, particularly important for nature protection law, particularly in the light of the ongoing decline of biodiversity globally and the biodiversity crisis we are witnesses at the same time than the climate and the pollution crisis. And that the judiciary can make the difference can be seen these days, I think, in the European Union. And the main pieces of biodiversity law within the European Union are the Habitats and the Birds Directive. And the Habitats Directive ensures the conservation of a wide range of rare, threatened, or endemic animal and plant species. And some 200 rare or specific habitat types are also targeted for conservation in their own right. And to implement the Birds and the Habitats Directive, a European ecological network of special areas of conservation has been set up, which is called Together Natura 2000, and that on the basis of proposals that the member states had to submit to the European Union on the basis of objective and scientific criteria. And that network covers, for the moment, 18% of the land area and should reach to 30% of the land and sea area in 2030. And member states are required to bring those areas in a favorable conservation status through management plans, and furthermore, these areas are protected by the so-called proper assessment. That's a form of impact assessment that is mandatory for all plans and projects that might have a significant effect on those areas. And plans or projects that are believed to adversely affect those areas may only be approved for imperative reasons of overriding public interest and subject to the condition that all compensatory measures necessary to ensure the overall coherence of Natura 2000 is protected. And the Court of Justice of the European Union, which is the final interpreter of European Union law, has developed over time an abundant jurisprudence on the Habitats Directive that is contributing in a decisive way to the effectiveness of that directive, and that jurisprudence helps also domestic courts in the member states to enforce it. So, to conclude, in this area, probably the European Union judiciary seems to have heard the call of the Johannesburg principles, and I think that it's pretty much needed given the threefold environmental crisis we are facing now. Thank you very much for your attention. Unfortunately, I cannot stay to the end of the panel because I'm here in Berlin at another conference of constitutional courts on climate change litigation. Thank you very much.
Thank you so much. Let me just say that it is important that you brought biodiversity into our discussion. We live in a time when climate change has become almost the main issue of environmental law. However, we should be careful because we have climate change as an existential threat to humanity, but there are other existential threats as well. And one of them is biodiversity decline and pollution affecting the most vulnerable populations in the world, as I was discussing earlier today with my colleague, Justice Eduardo Ferrer. So many thanks, Justice Levrisen, and I know that you are attending a conference of Chief Justice of Constitutional Court, and you are here at the same time with us. So back to Christina Pack for our last speaker.
Thanks, Justice Benjamin. Now we'd like to introduce our final speaker, Justice Samson Okongo, Emeritus Presiding Judge of the Environment and Land Court of Kenya. Justice Okongo.
Thank you very much, Christina. Good afternoon from Kenya, East Africa. Let me just speak briefly on what I consider as a unique challenge in the enforcement of environment rights, duties, and obligations in Kenya. In Kenya, I would say that we can be described as having an idyllic atmosphere for the enforcement of environmental rights, duties, and obligations. Our Constitution guarantees a right to a clean and healthy environment. Our Constitution gives standing to anyone in the enforcement of the right to clean and healthy environment. We have a framework law on environmental management and coordination. All treaties and conventions to which Kenya is a signatory are considered part of the Kenyan law. We have a specialized court where I sit, which only deal with environmental disputes and land. We also have, in addition to that, a tribunal dealing with environmental matters. So unfortunately, all these procedural and substantive laws for the enforcement of environmental rights have not translated to enhance environmental rule of law. As we all know, our role as judges in the promotion of environmental rule of law in most cases commences when a dispute of environmental nature is brought to court. So our unique problem in Kenya with regard to enforcement of environmental rights and environmental rule of law in general is what I would call a problem of access to environmental justice in a narrow sense. And the problem is the reluctance on the part of the public to bring environmental claims or disputes to court and other statutory tribunals. Environmental law, rule of law cannot be achieved if the public do not approach the courts and established tribunals. As Kenya is faced with several cases of environmental degradation, such as overexploitation of natural resources, pollution, deforestation, loss of biodiversity, dumping of industrial wastes, etc. But when the public cannot come to court for redress against these environmental violations, despite the existence of both procedural and substantive law and forums for seeking redress, our progressive laws on environmental protection just remain on paper. Just by way of an illustration, between 2013 and 2017, out of all the cases that our specialized court determined, less than 1% were environmental cases. This apathy in bringing environmental cases to court has been attributed to many factors that, due to time, I cannot go into, but I would say that there have been a number of interventions. The number of judges have been increased, the number of courts have been increased. We as a court have gone out to sensitize the public on the existence of our court and what we do. Recently, our Chief Justice has also established a special chamber or division in the city of Nairobi to deal mainly with environmental cases. So what I would say in conclusion is that having good procedural and substantive laws on environmental protection is not sufficient. I would agree with the former speaker, Justice Philomena Singh, that judges may have to go out to do more, particularly to sensitize the public on their rights. Thank you very much.
Thank you so much, Justice Okongo. You highlighted the importance of not just substantive law, but procedural laws as well. And the environmental rule of law requires a deep rethinking, for example, of standing to sue rules. To have good laws, good courts, but no cases doesn't deliver what society expects from the environmental rule of law. With that, let me thank all the speakers, thank my co-chair, Christina Pack, thank again the organizers, and I see now here Teresa Parejo, muchas gracias, Teresa, que no estaba antes con nosotros, and someone that is always present, although he's participating by video link, Professor Nicholas Robinson, the mentor of all of us. With that, I think it's fair to say that we had a short, but a great panel. Many thanks to all of you.
Okay. Thank you very much. Good afternoon, everybody. Buenas tardes, buenos días, buenas noches, wherever you're hearing from us. I'm very pleased to be here to have this, the moderation of this second panel. We've already heard from the judges all around the world. So now I turn to the diplomats, the NGOs, and the business sector. Myself, I come from the academic sector as well. I'm professor or director of the environmental diplomacy program at Pace University in New York. It's more of a pasantía, a practical training where the students go to the UN to learn about this. And all they want to learn is about environmental issues, but now they know it's about human rights, nature, and peace. And that's why I'm very glad to lead this panel today. And I also wear the hat of the International Council of Environmental Law. I am their UN representative in New York, following all the proceedings there. Following all these various issues that put us together. So with that, I'll just turn on to present my distinguished list of panelists, and I will start with the diplomats. First, we have Ambassador Fernando Curcio Ruiz Gomez. He's a Spanish ambassador at large for peacekeeping operations of the Spanish Ministry of Foreign Affairs and Cooperation. He's been previously ambassador in New Zealand, the Pacific, many other places. He's a lawyer from the Autonomous University of Madrid and started his academic career in 1989. He will speak to us about sustainability as our only future. So the floor is yours, Ambassador.
Thank you, Chair. Well, yes, thank you very much to the organizers and the partners of these panels, which are of fundamental importance these days. And I'm very pleased to participate, to bring my experience. I want to tackle this issue of sustainability because it is a question that is practiced by diplomats in our daily life, in our different jobs. The battle to incorporate a sustainable approach to international negotiations has never been an easy job. Talking about nature and peace could be tagged as idealistic. And this brings me to Don Quixote de la Mancha and the adventures of Don Quixote, Don Quixote in Spanish, which thought that we were in a battle, in an unequal battle against the realistic of this world. The idealistic, I would say, as me, have always been in this battle, and I want to bring to this table one of my first experiences in the real world, when I had to manage fisheries in Spain for many years. I was in charge to bring to the Spanish administration the plan of action of FAO against illegal fishing activities and unregulated and undeclared fishing activities. And I found myself quite isolated in this world of fisheries. It was a world of, indeed, a fierce battle against the last fishing grounds of the world. The Spanish administration, as many other administrations in the world, have always been very isolated, lacking this mindset that we're asking for today of international cooperation and sustainable approach for, in this case, for fishing activities. But that was a battle that Spain had to win, and indeed we did. We had to put in force this plan of action against the Spanish real problem of illegal fishing in the world with the flags of convenience. Ship owners who were flagging their ships in those jurisdictions who wouldn't ever apply international law of environment, of tax, of labor, and wanted to avoid this international law and undermine the efforts of coastal states or fisheries organizations to have a sustainable approach for fisheries. That is a battle that has been mainly or generally won these days. It's been eradicated, at least in Spain, but still we're waiting for many other countries to do their part. But today the main battle in the oceans is not only these fishing activities, it's to enlarge the marine protected areas. Marine protected areas were taken as an important tool to protect fisheries in the world, to protect oceans. They were established as a main tool in 2002 in the World Nature Summit. And in the Antarctic area, I had the opportunity to chair the Convention on the Protection of Antarctic Marine Living Resources for 2 years. We adopted 2 marine protected areas in 2006 and 2009 at the wake of this World Summit. But today, the problem is really difficult to solve. At those days, geopolitical forces in the world were quite stable, and we managed to establish 2 marine protected areas, the Ross Sea and the South Orkney Islands. But these days, when there is a fierce battle in geopolitical terms, it is really impossible to continue enlarging the marine protected areas. The Antarctic system is really a vulnerable system. The krill fishery, which sustains all the populations of the Antarctic, are at stake, not only because of the increased effort of fishing activities, but also because of climate change. And this is where we have to take action. Well, these are 2 cases where I wanted to share with you to make you see that law has to be implemented. It's not only the effort that you are doing in the world jurist organizations, but it's also a fact that we have to pass this message to the society, to the international organizations, to the big powers, to make this a real event, you know, the passing into practice of the law. But in my second part of this contribution to the dialogue of nature and peace, I want to deal with my real current job right now as ambassador of peacekeeping operations of Spain, and to touch on the closer and closer links between peace missions of United Nations and the crisis management, crisis operations of the European Union, the increased links with natural disasters of human origin. No one can deny these days that there are many missions of peacekeeping operations which are implemented or are deployed because of natural catastrophes. But the fundamental question we have to ask today is what the UN peace architecture on security and climate can do for integrating climate, peace and security in mediation, conflict prevention and peacekeeping efforts. And we should concentrate on the Security Council. At this point, I want to mention the group of friends on climate and security with over 60 countries, including all the European Union countries and Spain included, that are claiming for the Security Council and the UN agencies that should integrate nature and security at the same strategic level with a view to preventing conflicts across the world. I want also to mention the big issue or the big important event that took place in Madrid in 2019, the Summit on Climate, COP 2019 in Madrid. As a result of that summit, it was also held in Sevilla, the Summit of Climate, Peace and Security, where all the European Union countries claimed the importance of linking peace, climate and security. As a result of that summit, a strategic group of advisors were established in the European Union to influence all over the world on these links between climate and security. Also, as a result of that summit in Sevilla, we have been pushing at UN level to bring about what we call an omnibus resolution on climate security through the UN Security Council, which could help set a new international set of norms and practice about dealing about climate security. Also, because of that impetus, at United Nations level has been created what it is called the Mechanism on Security and Climate. It's a mechanism where we have 4 important instances of United Nations working together: the Political Affairs Department of the Office of the Secretary General, the United Nations Environmental Program, the United Nations Development Program, and the Peacekeeping Operations Department of United Nations. These 4 agencies are working together also to include climate and security in all the mandates of the peacekeeping operations all over the world. And this is specifically the case for the Sahel Strip in Mali, Niger, Somalia, Sudan, south of Sudan, where the climate conditions are changing rapidly, and because of the conditions of the tribes of this part of Africa, the security is at stake. Well, this is a practical result of all these international efforts. And I also want to mention at EU level our common security and defense policy, where we have set a set of guidelines, a toolbox that has to be used by all institutions of the European Union to bring about practical results on the application of environmental instruments in all our overseas programs, in humanitarian aid, in economic development. So we have established the need to have in place environmental advisors in all our programs, and this is a fundamental tool for, at the long term, bringing good practices to our host nations to include environmental programs in all their internal policies. And also to mention, to end my speech, our 13 crisis management operations developed by the European Union in Ukraine, Georgia, Armenia, Libya, Niger, Somalia, Central African Republic, Mali, and perhaps some others that I'm missing now, where we have a full set of norms, always to respect nature, environment in all our deployment of forces, civilian or military forces. So this is an issue that we have deep in our hearts in the European Union and Spain, and we'll stick to it in the future. So thank you very much, Mr. Chair. Dear panelists, I give you the floor. Thank you very much.
Thank you very much, Ambassador. And I have to say, I'm not doing very well my moderator role, but I could not stop Ambassador, because not only was he giving examples, and I thank all the students around here, thank you for coming, because I think that's the best, your examples on fisheries, adding the element of food, right? And then, of course, you built very nicely the idea of security and how it's intertied, and the complex of trying to make this work. So thank you for that. And then I'll turn to the ambassador on my left, on your right, Ambassador Fernando Fernandez Aguayo. He's the head of the Human Rights Office of the Spanish Ministry. I'll just introduce him as a diplomat of career. And I do know he's been working hard on climate change, the effect of the infants, of the child, and he'll speak of the impacts of climate change on human rights. Ambassador.
Thank you so much for this kind invitation to participate in these dialogues on nature, justice, and peace. No one can deny now the link between climate change and human rights, as climate change has a negative impact on the enjoyment of human rights, such as the right to life, to health, water and sanitation, for instance, especially by the most vulnerable people, as has been said before. These impacts is now such a scale that it will continue to pose great challenges to the promotion and protection of human rights all over the world. Since 2008, the Human Rights Council in Geneva is addressing these negative impacts of climate change on human rights. In 2012, the Council created the mandate of an independent expert on human rights and environment. And however, it has not been until October 2021 that the Human Rights Council adopted a resolution which recognized the rights to clean, healthy, and sustainable environment. The Council also agreed to establish a special rapporteur on the promotion and protection of human rights in the context of climate change. With the creation of this mandate, a significant step has been taken to address these issues systematically and comprehensively. This will make possible to clarify the legal obligations of the states provide assistance and support, and even open up some sort of access to justice through individual allegations against states. This is especially remarkable for you specifically. But then later on in July 2022, the United Nations General Assembly adopted a very important resolution based on the one previously adopted by the Human Rights Council that declared the access to clean, healthy, and sustainable development as a human right. This is very important, and this constitutes another important step in the fight against climate change and its effects on nature, recognizing the fact that climate change and environmental degradation are part of the most urgent threats for the future of all human beings. I would also like to mention very briefly, because I know that we don't have much time, the work of human rights defenders, especially those who work for the protection of the environment, who are among the most vulnerable of all. And I would like to mention that the Ministry of Foreign Affairs, European Union Cooperation, has a temporary shelter program for human rights defenders at risk. And we, of course, we give protection to environmental human rights defenders. Actually, we have one very young environmental human rights defender who is just 13 years old. Only 13 years old. You can imagine the risk he has to face in his country to be living here with his family. So you can imagine. Yeah, do you know him? Yes. And also there's another one of the immediate effects of environmental degradation on biodiversity loss is the difficult access to water and sanitation. The promotion and protection of human rights to drinking water and sanitation is one of the priorities of the Spanish foreign policy on human rights. But in any case, I would like to maybe to finish with this message. We must continue working to prevent the threats that climate change and environmental degradation pose to human beings, and as well as ensuring that people affected by them have access to resources and adaptations measures. We must increase international cooperation and strengthen our efforts to ensure a clean, healthy, and sustainable environment for all of us. Thank you so much. I think it was 3 minutes.
Thank you, Ambassador, for record time breaking and also for complementing this very significant decision from the General Assembly. It was 50 years in the making, and it was strategically designed to pass like in midsummer. You know what happens in midsummer, right? So a lot of work of many delegations, and it's more about that work, slow but important work of diplomacy. But it requires a lot of consensus. So events like this, the work we all do, get us there. And actually, before I forget, the negotiation to protect biodiversity in the high seas is also concluding. So diplomacy is slow, but it's integrating biodiversity, the use of nature. And so let's believe a little bit or give it a chance, and let's contribute to the creation of this international framework that it involves not just bodies, but all of us. And with that, I'll move to the NGOs. Right? We have Maite Monpó here. She's the director of Stop Ecocide in Spain. She's from Albacete, a lawyer, and has dedicated her entire life to human rights, peace, and the environment, involved with Amnesty International, Greenpeace. So with that, she'll talk to us about ecocide law as a keystone for a peaceful and thriving planet. The floor is yours.
Well, first, thank you to the Carlos III University for inviting me and creating this fantastic arena to talk about such important issues. We are all witness of the massive destruction and damage to vital ecosystems that is taking place all over. At the root of this severe harm to nature, what is generally known as ecocide, we find that it is not illegal to cause it, as there is no specific law to criminalize at international level, the massive destruction of environments. This ongoing aggression against the natural world does not only affect ecosystems themselves. When serious damage to nature takes place, it also affects the human communities that directly depend on that ecosystem for their livelihoods. Those who peacefully try to prevent the damage or publicly denounce it are also victims of harassment and extreme violence, as it sadly happens so often with the environment defenders, as you have mentioned, and especially being the case of indigenous communities. Summing up, violent conflicts between communities are becoming more and more frequent, as the ones who are directly affected by the deterioration of nature are forced to move to other territories where they are not always so very welcome. In this way, the destruction of the natural world is also recognized as being one of the main causes of many current conflicts. So, all in all, we find that there is a direct link between the destruction of environments, conflicts, and strong violations of human rights, a terrible circle sustained by the lack of a protective international criminal law to stop impunity and corruption. At the same time, increasing numbers of people, communities, and companies are trying to build up a different relationship with the planet, basing their modus operandi on returning to a harmonic relationship in order to achieve a feasible and thriving future for all living beings. Historically, the radical changes in societies have been accompanied by the law, and here it is more obvious than ever. Out of question is the fact that this change in the socio-economic paradigm needs to be supported by a criminal law that makes accountable the ones who are most responsible for those severe harms to the environment, a law that also protects the protectors of nature and ensures a livable planet for the generations to come. Making ecocide an international crime is absolutely necessary because it is about protecting our common home, but in particularly because in most cases of ecocide, the effects of the harm are transboundary and are often caused by transnational corporations. The establishment of individual criminal liability for those who make the decisions will deter them from causing ecocides and will help to end impunity for those who commit criminal acts against the basis of life. And finally, it will set the red line that neither companies nor investors will dare to cross, as it will imply such a high risk in all respects. It also acts positively, encouraging investments and innovation towards activities that will be neither harmful nor polluting. Being recognized at the International Criminal Court as one of the crimes that threaten the peace, security, and well-being of our world, an international ecocide law will help to create peaceful societies living in harmony with their environment, where it would be ethically and legally unacceptable, even unthinkable, to cause severe harm to nature. Thank you.
Thank you, Maite. I'm sure we'll hear more about environmental defenders of 13, 12, 10 years old, and very much more about ecocides, so thank you for framing the issue. And now I'll continue with a UN agency representative from the UN Agency for Refugees. We have here with us Sophie Muller. She has been at the agency for many years, starting in 2000 as legal advisor, senior policy advisor. She has been on the field. So we were very pleased to have you here to talk about human rights as, I think you frame it even further, climate change as and forced displacement as a threat multiplier.
Thank you very much. Indeed, and thank you for counting with us, with UNHCR, for this debate, for this panel. We've just been speaking about the impact of climate change on human rights and on peace, and therefore, as a result, forced displacement. This is what I will be talking about, starting with a few data. Just about today, yesterday, we reached 103 million forced displacement in the world, forced displaced persons in the world, out of which 32 million are refugees, 51 million are internally displaced, 4.9 million are asylum seekers, and 3 million are stateless persons. Over the last decade, 4 out of 5 newly displaced persons have originated from countries highly vulnerable to impact of climate change. In 2021, 95% of all internal conflict displacement occurred in countries that are highly vulnerable to impact of climate change. And around 80% of new refugees and asylum seekers originated from the same countries. We're talking about Somalia, Sudan, Afghanistan, and Yemen, for example. We're witnessing how the phenomenon that are driving forced displacement are becoming increasingly complex and every time more linked to the impact of climate change. The results of the root causes, as we were saying, that are increasing the threats to individuals and therefore increasing the reasons for their forced displacement. Climate change is an emergency in every continent. In particular, when the dramatic effects are impacting most vulnerable people. Refugees hosting countries as well, Pakistan, Uganda, or Bangladesh. Therefore, for us, the impact of climate change are in 3 areas. It triggers displacement or secondary displacement for first country of asylum. It worsens living conditions of refugees and of forced displaced persons wherever they are. And it prevents us from finding solutions for them. It prevents voluntary returns. It prevents the possibility of integrating where refugees are when they are in a country, in a host country that is already vulnerable to the consequences of our climate change. A few examples. When scarcity, when the lack of natural resources is becoming a commonality in a country of asylum or in a country of origin, it triggers fights for those resources. When the lack of resources therefore results in discriminations, it results in violence, it results in conflicts, as we've just discussed. All this results in further displacement, and people not having the resources to be able to sustain themselves and fighting among each other to get to those resources. And very often it regenerates old conflicts that had sort of settled down. I had the opportunity to work in the Philippines following Typhoon Haiyan. And this is exactly what we were living. I was part of the coordinators for protection there. And the Philippines had, I was really happy to see how many representatives of the Philippines have been present in this event today, because it is indeed a country that has been and continues to be very vulnerable to the result of consequences of climate change, and had in his history a lot of internal tensions, a lot of internal complexities that has been increased as a result of climate change. And Typhoon Haiyan was one of those examples where we were trying to resolve internal displacement that had nothing to do with climate change, and the typhoon made those tensions more prominent increase the displacement, increase the challenges we were facing in finding solutions for that. So what do we do in UNHCR to respond to that situation? Well, helping government to find, to reflect on policies, to reflect on legal infrastructures, to respond to the consequences of climate change. Ensuring that the refugee definitions takes into account the fact that the root causes of displacements are increased by climate change. And also, for ourselves, being greener. And I think it is upon us as activists against climate change to be also ourselves greener in our way of operating. We are making an effort in UNHCR to see our work in a different way, to build refugee camps in a more sustainable way, to accompany refugees in finding responses to climate change themselves and be activists themselves. Thank you very much.
Thank you, Sophie, again for giving us examples, and as you see, it's just incredible to see how my fellow in the panel deal with such a difficult issues and how they explain them, with such a relief that hopefully that invites everybody to work in this very complex, levels that require more and more change, in a positive way. So I'm very happy with all my panelists, and that makes me reach my final panelist to represent the private sector. She is now the head of sustainability for Iberia, but before moving to dedicate most of her life, because probably not all of it is just on aviation, she was an academic right here at the University Carlos III and helped bring ICEL to have its secretariat here. An academic, extensive writings, incredible work also in New York with sustainability. So now I can talk to her, Teresa, this is your captain. We've made good progress on air, and I'm going to give you your full 3 to 5 minutes. Please tell us, how can aviation help in this role?
Thank you, Victor, and thank you to the university. I love University Carlos III. So I guess everybody now is thinking, why is the private sector here, and precisely an airline? It's kind of strange. Well, it's not. I'm going to show you why it's not so strange, to help with justice and peace for human being in general. So as a starting point, perhaps recall what just Ambassador Fernando Fernandez just mentioned for international cooperation. We not only we need international cooperation, which I agree, but we also need cooperation among everybody here, and precisely between the public and the private sector. And the private sector plays a key role, and precisely for this objective, or having justice and peace, aviation is critical, I think. So aviation has been spotted recently as a devil for climate change, as a devil for environmental impact. And it's kind of true, I must say. It's not wrong. Aviation is doing harm, but not only aviation, all human activities are damaging our environment. That's a reality. But I have to say, and this perhaps is good news for you, or at least for me, that we're working hard to lessen our impact in the environment, and doing the best we can in order to decarbonize our activities. That's something that is real, that is being done seriously and with very strict regulation, at least in the European Union, and I'm very happy for that. So to give some numbers, aviation currently represents between 2 and 3% of global emissions, and I don't like to say that this is, well, so you see it's not a problem. It is a problem, mainly because in the future, in the year 2050, where all economic sectors will be decarbonized, perhaps because they can be electrified with renewable energy. Aviation won't. So instead of representing 2-3% in the year 2050, we will represent around 22% of global emissions, which is a lot. And even more, and I come to you and the NGOs, I think aviation represents a climate justice problem, because these 2-3% of emissions are done are caused by the 10% of global population, and even more, only 1% of the population in the world flies more than once a year. So it's pretty bad, I think. But we are working to do things much, much better. But having said this, which I hope my boss doesn't listen to me today, but this is true. But we have a very, very strict, as I said, decarbonization strategy put in place already. But today, I want you to understand that there's another side of it. There's another side of aviation, and this is the one that links today with what we're talking about. And this is that aviation plays a key role in the social part of sustainability. And I've been working with Sophie, a friend of mine, and we've been trying to collaborate. And we hopefully we'll strengthen our relationship. But it's been key for the pandemic, when everybody was out of their homes and wanted to come back, to get the equipments, the masks and everything from China to the world. And it's key for connectivity with people when you want to go home, you want to see your friends, you want to see your family. It's key when there are natural disasters and you need aviation to go really fast where this has happened. And if we're talking about Spain, it's critical, because we are like kind of an island geographically in Europe, and we need to connect our territory, which has lots of islands. So it's very, very much a key service for us. And not only to guarantee connectivity, to maintain our tourism industry, which represents more than 12% of our GDP. And you have to know that 80% of the tourists come to Spain by plane. And so knowing this, Iberia, and then I come to Iberia, has tried to measure the social impact of its activity. And we know today that our activity, just our activity, direct and indirect, represents 0.6% of the GDP in Spain, and creates 0.9% of employment in Spain. So it's huge. Our contributions to our social impact or sustainability from a social perspective is very, very important. So I don't want to talk more. I think the numbers give an idea of what I'm talking about, but just this, what I just said is just to let society, you young people and others here, my colleagues, that to think about aviation not only as a problem to the environment, which it is, and we are working on that, but also that to understand the role of aviation plays a key, an essential role to guarantee human well-being, which is also to say justice and peace in our society. Thank you very much.
Thank you, Teresa, for your words, your blunt way to present the problem and to present the solution. We all know that you're a clear thinker, problem solver, and that we're sure that's why Iberia put their eyes on you, and academia can work. So keep doing what you're doing. So we've made good time, as I said, and that makes us probably have a question or two and a reflection, a minute reflection from any of the panelists, if there's anything pressing from the panelists that would like to kind of finish off, we'll do that, and if not, I'll pass it on to
I would open to the public if they want to ask
Yeah.
a question, perhaps.
Yes, do we have a mic, or I'm sure you... Yes, come on over, and then I'll repeat. So please, the mic is coming.
Hello? Yes, it's working. Hello, I'm Ana Barreira, founding director of the International Institute for Law and the Environment, and I have 3 questions. The first one is a comment for Ambassador Curcio. I know well the time when you were the Director General, because those years I was a lawyer for Oceana, and this is my comment is linked to the previous panel, because we were litigating for access to information on the owners of boats that had permits to fin sharks on board, which was linked to the POA, the Plan of Action for Sharks, FAO, and also and the work I did was about mercury pollution in fisheries products and many other aspects, also on bottom trawling, and we had very important wins those years. So, but my question is for Maite. Maite, you were mentioning about the transboundary impacts of transnationals, and I know that the Ecocide initiative has been on place a long, long time ago, and it takes time to make it a reality. So have you ever tried, I mean, your initiative, because when we are talking about the transboundary impact, we have principles of international law, which are even customary international law, like Principle 21 of the Stockholm Declaration or Principle 2 of the Rio Declaration, on the principle not to cause, the sovereignty over permanent, the permanent sovereignty over natural resources, but the obligation not to cause transboundary damage. So have you ever tried, or your initiative, to use this principle in courts, even though still the Ecocide, because although the Ecocide is not yet in place, it's not a law, there are other instruments in law, in international law, that might be useful for this. And for Teresa, what about green hydrogen in the aviation sector? Because green hydrogen now, it's the golden energy, at least for the European Union. So, okay, thank you very much for your presentations, were very interesting. Thank you.
Thank you, Anna. Yeah, well, in Stop Ecocide, we are aware that there are different ways of getting ecocide implemented, and ecocide crime implemented. And studying all the different choices that we have to get it, we have gone for the creation of the international crime at the International Criminal Courts due to a few reasons. But we don't, we are in an international campaign that fights for getting this, for getting the ecocide inside the Statute of Rome of the International Criminal Courts. And we don't work in any other approach because we are just centered in this objective, even if we know that there are other choices and there are other ways of getting, this implementation of a real crime of, the criminalization of the severe harm to nature.
Thank you, Maite. And finally, the future, hydrogen.
The future, very future, we will never see a plane, never, never, never. None of us will see a plane of hydrogen. So the present and the future for a sustainable aviation is the so-called sustainable aviation fuels, which in terms of life cycle can reduce emissions up to 90%. But the problem is that there's not enough SAF. That's how we call it right now. But the regulation, at least in Europe, starting in the year 2025, puts some binding targets of production, and we are hoping to have some of that, but the price is very, very high. So hydrogen, yes. Airbus has said that they will have an airplane in the year 2035. That will be a one one airplane, and it will be a small one just for short distances, for perhaps 10 passengers. But flying Madrid to Bogota or Madrid to Lima, you will never see a plane flying with hydrogen long distances for like in the next 50, 60, 70 years, perhaps in the future. But perhaps in the future, we will not travel like this. We will travel telepathically or whatever, so you never know.
Ambassador Fernando, you want to have some closing remarks, and then I'll just thank you.
No, thank you, Chair. It's just because our friend from Oceana mentioned you used to be in Oceana, and you mentioned our work in the Department of Fisheries about sharks. And it's true what you said, and I really commend the work that you are doing, because it's really necessary in Spain and the European Union. But we have to be precise when you talk about a special fleet doing something that may seem to be harmful. When you take national or international measures, such as restricting the access to sharks or swordfish to a particular fleet, you have to do it in equal terms at the international level and European Union level. There is no country in the world that could restrict its industry, to damage its industry, if all the stakeholders, all the actors in that industry are not doing the same. Otherwise, what you provoke is the escape, or some people leaving your country and going to another country to do the same harmful activities. And for instance, the question of flags of convenience, that would have been the case if we restricted the activities here in Spain. They would have gone to another flag. Not to a flag of to another flag of convenience, not the Spanish one. So this is something that you have always to reflect, but you know perfectly that, you know perfectly.
Okay. You'll continue, and I just want to wrap it up and thank my panelists. I don't know if we've paired the judges, but we gave it a good try, and because of a very good discussion. Thank you very much to all.
Good afternoon, ladies and gentlemen. Hello. Good afternoon. I'm really amazed. We are on schedule, almost 2 or 3 minutes late, 4 minutes late, but it's amazing. I am Silvia Gallard. I am the Director of Institutional Relations and Sustainable Development of the Universidad Carlos III de Madrid. I want to thank in the first place the organizers of this event to invite me and give me the opportunity to very briefly state the commitment of our university with sustainable development, the 2030 agenda, and I also want to state the role or underline the role of the universities as promoters of high-level debates on such transcendent issues as the ones that we have been discussing today, this afternoon. I'm delighted to welcome you to the last session of this dialogue on nature, justice, and peace, in which our distinguished guests will put forward their closing remarks after a very inspiring, I would say, and interesting series of panels that we've had this afternoon. My only regret is that they could not last longer, because all the participants have been really, really interesting, amazing, and really, really great. In the first place, I will give the floor to Professor Christina Voigt, Chair of the IUCN World Commission on Environmental Law, Co-Chair of the Paris Agreement Implementation and Compliance Committee, and Professor of Public International Law at the University of Oslo. She's with us online, so please go ahead.
Thank you so much. Just to make sure you can hear me, can you confirm if I'm audible? Thank you so much. Well, I would like to start with thanking the organizers. I'd like to thank ICEL, the International Council of Environmental Law, in particular Professor Montserrat Castellos, but also Victor Tafur. I would like to thank the Global Judicial Institute on the Environment, Justice Antonio Herman Benjamin, and many more who brought together this pre-event for the big event which will take place in New York in July. And on behalf of the IUCN World Commission on Environmental Law, I would like to express our gratitude and our privilege for being partner in this event here and in New York, and being proud of working together with all of you. I would also like to thank very much all the participants, the judges, justices, the diplomats who took their time coming here, speaking here, NGOs, I'm sorry, and business representatives. It was a very important interaction of different views, but it was carried by the same message and the same meaning that peace, justice, and nature are indispensable and interrelated. I think we all agree that justice is impossible without peace, and this is something, I guess, that the current war in the Ukraine inflicted by Russia very clearly shows us now in the second year. But justice is also not possible if we do not include the environment, the natural environment upon which we all depend in everything we do in our deliberations of justice. And in this context, I would like to make two brief remarks. The first one is that several of the participants spoke about the rule of law for the environment. And this is, of course, something the World Commission on Environmental Law very strongly advocates and works for. But in this context of talking about the rule of law for the environment, we've heard about so many different dimensions. It's a complex concept, but I would like to scale it down to three important dimensions. One is spatial. Rule of law for the environment is something that applies in a spatial context, whether it's on the space of a city or a village or region or country or globally. And that brings to the core of justice the question of North and South equity, of intergenerational equity, of how we include the Global South in the deliberations of justice. The second dimension is the temporal dimension. We're looking at justice and peace and nature now, but it's something that evolves over a long time and is of relevance to those that are young today and grow up in a very different future, which will be marked by nature loss and climate impacts. And that aspect of transgenerational justice that applies to us now into the future or to future generations is a very important aspect of the rule of law for the environment, but also in the deliberations of justice, peace, and the environment. And here we recently have very significant developments where intergenerational justice was recognized in different fora, in different court decisions by the UN System Chief Executive Board, in recognizing the common principles for future generations. There was a book recently published by the World Youth Council on Justice on youth climate justice, and just very recently, the United Nations Special Rapporteur on Climate Change and Human Rights, Ian Fry, he called for general inputs on the issue of climate legislation and intergenerational justice, with a deadline of 25th of May for those of you who may be interested. And all this, I just wanted to bring to the table to think back to the concept of sustainable development, because all these elements, these different dimensions, are part and parcel of the concept of sustainable development as it was defined in 1996 in the Brundtland, 1986 in the Brundtland report on our common future, which stated that development is a sustainable development is development that meets the needs of the present without compromising future generations to meet their own needs. And that beautiful sentence and that beautiful concept and principle was relevant in 1986 as it is really importantly relevant today as well, and can be used in our deliberations, both procedurally in courts, but also in international relations. The final aspect that I would like to highlight is many speakers have spoken on the close interlinkage between climate change, climate impacts, global instability, and justice. And here we have, of course, one core global agreement, the Paris Agreement, which is currently the only global agreement and the strongest and perhaps the best that we have. In my work as the co-chair for the Paris Agreement Implementation and Compliance Committee, but also in my academic work, I see that currently several states, but also academics, kind of withdraw their support to the Paris Agreement. And I think this is a very dangerous tendency and trend. And I would like to encourage everyone to defend it for what it is worth, and to give it the full support and full effect that can be given to an international agreement which needs to be implemented domestically. It requires an international collaboration, it requires domestic interpretation and implementation, and our overall understanding of what it does and what it can do. With that, I think I would like to thank everyone for the wonderful discussions that I've been able to listen to only remotely, and give the floor back to Madrid. Thank you so much.
Thank you very much, Professor Voigt, for your comments and insight. We will now move on to Justice José Igreja Matos, President of the International Association of Judges, who is also online somewhere.
Portugal.
Portugal, okay. So maybe he's mute. Okay, I cannot see. Maybe you can unmute. Yes, there you are.
Hello, hello. Wonderful to be with you. Very honored to be present in this launch event, Dialogues on Nature, Justice and Peace. What an impressive and challenging title. Well, as you already said, Mrs. Moderator, I am the president of the International Association of Judges, and I will focus on the institutional framework, since my presence here is mostly or purely institutional. I speak as president of this organization, representing judges associations or similar bodies from 94 countries. Well, 2 years ago, EAJ, the International Association of Judges, defined as one of the top priorities for us the environment. Since then, a lot of work has been done. EAJ assumed a larger role in the discussion of conservation of nature. A successful example was our participation in the conference Stockholm Plus 50, where judges gain status and importance in the center stage of environmental policies. For our mission, we were very fortunate, very lucky of working with a fundamental, crucial partner for our organization, that is the Global Judicial Institute on the Environment, presided by Minister Antonio Herman Benjamin. This solid partnership between EAJ and the Institute gained recently a new momentum. During the past months, I did my best to try to put together the Global Judicial Institute on the Environment and the World Jurist Association, presided by Professor Javier Cremades, and here represented by my friend Diego Solana. The dynamics of both organizations, mostly due to the extraordinary capacities of their leaders, Antonio and Javier, claimed for this novel cooperation. The results already started and are being materialized in this event, and as we speak. The present event announcing the World Law Congress to be held in New York next July materializes the finest path to sustain a fundamental mission of protecting nature, affirm justice, and build a more peaceful planet. That is the reason academia, here represented by the University Carlos III from Madrid, jurists, diplomats, professors, other organizers and partners, the International Council of Environmental Law, the UNEP's Law Division, and the World Commission on Environmental Law, a special warm welcome to President Christina Voigt, assembled today for this noble mission. Therefore, formally, in an institutional manner, the International Association of Judges praises your holistic approach, essential when tackling with these matters, expresses its public unconditional support to your decisive work, and reaffirm an unequivocal pledge of judges worldwide to our common aims. The excellence of the panels of today's event projects a successful Congress in New York and a successful side event based on these topics. At the present difficult moment with a gloomy ongoing war, our union, our combination of efforts is absolutely essential. EAJ will continue to provide its best efforts to congregate goodwill women and men, engage organizations devoted to our civilizational values in pursuit of rule of law and of a more inclusive, sustainable, and peaceful society. Let's move forward. Let's be together as one. And this is the main message I wanted to transmit in this institutional background that motivates my presence here today with you. Thank you for your attention.
Thank you very much for your optimism and this wish to move forward, which we definitely need. Now we'll move on to Ambassador Orlando Leite Ribeiro, Ambassador of Brazil to Spain and the Principality of Andorra, who is here with us in the room. Mr. Ambassador.
Well, thank you so much for the invitation. It's an honor to be here, and thank also to Minister Herman Benjamin, who invited me also to be here. Well, I was asked to say a few words about how Brazil stands in this important issue. As you all know, in recent years, deforestation rates have increased in Brazil. But the new government is firmly committed to strengthen Brazilian government environmental policy again. And I say again, because Brazil has a consistent track record of environmental policy. The right to an ecological balanced environment and the government's obligation to defend and preserve it are embodied in our Constitution of 1988. In 1992, the year I started my diplomatic career, we hosted in Rio the first United Nations Conference on Environment and Development. After the Earth Summit, the environment and the idea of sustainable development never left the public agenda. We have a modern and strict forestry code, which imposes the obligation to preserve sensitive areas and to maintain a portion of the native vegetation in rural properties. And they do so without any pay. They don't get paid to do that. That's an obligation. Our energy matrix is one of the cleanest of the world. While the developed world talks about energy transition, Brazil already has an electrical matrix in which renewable sources represent 83% of the total. That means less greenhouse gas emissions and less impact on the climate. The new Brazilian government demonstrated the importance it attaches to the environmental agenda even before taking office, when President Lula, as president-elected, participated in COP27 in Cairo last November. There, we presented the candidacy of Belém do Pará to host COP30. The Amazon Fund was reestablished the first day of the government. Since then, Germany, Norway, the United States, and other countries have resumed their investment to finance projects to reduce deforestation. Brazil takes care, the world support, everyone wins. In addition, this year, The Amazon Summit should be held in Brazil, with the presence of the 9 countries that make up the Amazon Cooperation Treaty Organization. The objective is to coordinate and discuss a view of the Amazonian countries of the region itself. It is not without reason, therefore, that President Lula has said, and he said it here in Madrid at the press conference with President Pedro Sanchez, that Brazil is back. This return of Brazil, however, means approaching the preservation of the Amazon from a perspective of sustainable development. The Brazilian government is committed to a zero deforestation in the Amazon by 2030. We do not, however, want to transform the region into an untouchable sanctuary of humanity. We want to transform that region into a major international research center where scientists can study our biodiversity in search of solutions for the pharmaceutical and cosmetical industry, for instance, generating quality jobs for 25 million people who live in the region. Preserving the Amazon does not and cannot mean segregating these citizens and confining them to an hospitable space. But the quality of life and increased income for these people can be achieved without cutting down trees as a pretext for progress. This is how Brazil understands the concept of sustainable development in the region and how we will defend in the world. Thank you.
Thank you very much, Mr. Ambassador, for sharing these very encouraging initiatives and policies of the Brazilian government. We will now give the floor to Professor Nicholas Robinson, Executive President of ICEL, Chair Emeritus of the WCEL, and Emeritus Professor at the University of Pace in New York. He's also online. Welcome, Professor. The floor is yours.
Muchas gracias.
We cannot hear you.
It's a great pleasure to be with you all.
No. There is, the micro is, his micro is on, I cannot see. Now, maybe, sorry, could you?
Yes.
Yes, now we can hear you better. Please go on.
Thank you. I apologize for the technical problem. I look forward to our meeting in July in New York, where many of the ideas from this symposium will be presented and developed into much more detail. We have these 3 crises: the climate change, the biodiversity loss, and the expanding pollution. We know we have to add a 4th problem, which is the pandemic of COVID-19. And there will be another pandemic if we are not careful. So it is a time for action. We have enough law. We have a great understanding of how to implement the law. But if we look at the 17 Sustainable Development Goals, they have not been moved forward with the alacrity and the urgency that each of them requires. We have enough treaties, but we still need the plastic treaty and further treaty development. But we cannot wait for the treaties. It takes too long to develop treaty law. And we need action on these crises immediately. So what can we do? We already have, in the example of many countries, innovations that are achieving and attaining the individual sustainable development goals. We know how to provide clean water and sanitation. I was at the United Nations Water Conference this last spring, and all of the countries agree we need to act on water. It is a human right, and we know how to do it. We must prioritize the attaining of good sanitary conditions and clean water, and then many good benefits will flow from that. You don't displace people and have environmental migration. You don't deny people their basic human rights. So the United Nations, when it adopted Resolution 76/300, recognizing the human right to the environment, created a foundation for accelerating action to attain the Sustainable Development Goals. Some places like California just now, for instance, has adopted a new law, Senate Bill 54, on plastic pollution prevention and packaging producer responsibility. They want to phase out many uses of plastic. We have alternatives to plastics. We don't need a treaty to begin restructuring our supply cycle for substances like plastics. We also have in climate change the opportunity for immediate action. New York State, where I live, has adopted a plan to, in each sector, begin to provide increased mitigation and adaptation. And this has taken 5 years to prepare. It affects all sectors of our economy and life, and it will now be binding law beginning at the end of this year. So we'll begin to see a role for the courts. The courts are going to have challenges to these reforms, and we're going to need enforcement of these reforms. So we have basically an ecosystem of environmental justice that is emerging. As the action to solve our problems becomes clear, applying that action will require judicial intervention. And this is not just the role of judges. We have to think of our roles as law professors and our law students. We must not just study the law, we must plan to implement and apply the law. Similarly, it is a role for lawyers and bar associations. And this is why the world jurists in their meeting next July will have an important focus. The lawyers must bring the cases to the courts. And then finally, we have a recognition that all the reforms that we need to make are not linear, they're not uniform, they're not adopted in every region consistently. Rather, they pop up like the flowers in the spring. We must nurture them and study them when they emerge, and then replicate the good reforms as rapidly as we can. So this becomes our challenge, how to do this. I want to thank the organizers of this extraordinary symposium today. I've learned a lot listening to everyone, as I'm sure we all have. I wish I were in the Salon de Grades at the University Charles III of Madrid, but I regret I am not with you. So I will raise a glass to toast you at the end of the day and wish I were with you for the evening. Thank you very much. Muchas gracias.
Thank you very much, Professor. Call for action, awareness raising, and innovation are things that universities are supposed to do, and we are working on that really, really hard because it's needed, and we have a role to play in all these besides studying law and besides teaching law. We'll now move on to our next to our final panelist, which is Justice Antonio Benjamin, who has already participated in the first panel, Chancellor of ICEL. So, Mr. Benjamin, please, you have the floor.
Thank you, Sylvia, for your excellent coordination of this closing session. Many thanks to the panelists that we had, Professor Cristina Voigt, Justice José Igreja Matos, Ambassador Orlando Leite Ribeiro, Professor Nicholas Robinson. I think all of them have already summed up the basic points that we discussed in the two previous substantive panels. The first one on a dialogue on justice and nature, and not just about judges, because justice is not about judges, or at least it's not only about judges. We might have terrible injustice done by judges, and this has historically been done in respect to the way we treat nature and other living beings and the foundations of life. In the second dialogue, we discuss peace and nature, and the question that the speakers left is whether we can make peace with nature. And the conclusion is that if we do it, then we might have peace among us, not just between us and nature. And that's a very profound message that the speakers left in that panel. Since I'm the last speaker, let me thank the organizers, Professor Montse. It's not Professor Montse, it's our dear friend, our colleague that is this wonderful partner in everything we do in ICEL and ICEL in collaboration with the other institutions. Many thanks to the university, to your colleagues. You are the very best hosts we could expect. And I do know that since I'm the last speaker, you are all waiting for the final word, and that's it. Congratulations to all of you. Thank you.
Well, my turn to say the very, very last words on behalf of the university. Thank you for being here. It's been a pleasure to host this session. And, well, thanks for your nurturing contributions, insights, for being precise, concise, condensed. And I hope that you have a nice afternoon and weekend. Thank you very much.